Good afternoon, students. Earlier we discussed about Article 32, which is right to constitutional remedies, and about the three writs which can be issued by the Supreme Court or the High Court for the protection of our fundamental rights. Now we discuss the fourth writ which can be issued by the Supreme Court or the High Court, that is writ of certiorari. The word certiorari means to be more fully informed. By this writ, the lower court is asked to hand over the record of a particular case to the higher court. In Hindi, the writ of certiorari means पूर्णतः सूचित करो. This writ can be issued by the higher court to the lower court that to give all the documents regarding a special case which is running in the lower court. इस रिट के माध्यम से कोई भी जो उच्च न्यायालय है वो निम्न न्यायालय को आदेश दे सकता है किसी पर्टिकुलर केस को लेकर कि आप उस केस की सभी जानकारियां, सबूत, चार्जशीट, गवाह जो भी हैं वो मेरे पास भेजें. तो ये कौन सी है? रिट ऑफ certiorari. Next is writ of quo warranto. This writ is directed against a person who is usurped an office. It calls upon the person to show under what authority he holds the office illegally. अधिकार प्रक्षालेख in हिंदी, किस अधिकार से? Under what authority? Suppose any person is doing for any work but he has not right to do that work, then the Supreme Court or the High Court can issue the writ of quo warranto. किस अधिकार से आप इस ऑफिस में या ये काम आपने किया है, ये भी एक रिट है जो सुप्रीम कोर्ट या हाई कोर्ट के द्वारा किसी भी व्यक्ति से पूछा जा सकता है कि आपने किस अधिकार से विदाउट अथॉरिटी आपने ये काम किया है. सो दीज आर द 5 रिट्स which can be issued by the Supreme Court or the High Court. Next topic is related with judiciary as the guarantor. You know that right to constitutional remedies has made the fundamental rights in the Indian Constitution effective. What is important with regard to the Supreme Court's power is that the right to move the Supreme Court to issue such order or directions are guaranteed and cannot be suspended except when a proclamation of emergency is in force. We discussed about the 3 types of emergency. First emergency, national emergency by Article 352. Next emergency is state emergency, Article 356. And the financial emergency is like Article 360. I want to tell you about the national emergency which was put by Shrimati Indira Gandhi in 1975. At that time, mostly rights was suspended by then the Prime Minister Shrimati Indira Gandhi. But after 1975, an amendment took place in 1978 by the 44th Amendment. The Supreme Court gave a decision, or by the 44th Amendment, there was a legal document prepared by our parliamentary system that Article 20 and 21 cannot be suspended by any kind of emergency which is given in Article 359. इसमें ये बताया गया कि इमरजेंसी के दौरान भी हमारे जो आर्टिकल 20 हैं और आर्टिकल 21 राइट टू लाइफ, प्राण और देह की स्वतंत्रता, इन अधिकारों को हमसे कोई नहीं छीन सकता है क्योंकि ये अधिकार किसके द्वारा गारंटेड होते हैं? जुडिशरी के द्वारा गारंटेड होते हैं. नेक्स्ट, judiciary therefore is the custodian and the guarantor of the fundamental rights. This has been made possible because judiciary is an independent and autonomous institution within the Indian Constitution. We have 3 organs of the government which are working independently because there is a division of powers among the 3 organs of government. Next topic of this chapter is critical evaluation of the fundamental rights. Some people, those who are critics that the fundamental rights which are given in the Indian Constitution, they are not appropriate, they are not in appropriate manner. So on what basis these fundamental rights are criticized? The part 3rd of the Constitution dealing with the fundamental right has been criticized on the following grounds. The Constitution does not guarantee such rights as the right to work and right to economic security, etc. As you know that in NREGA, National Rural Employment Guarantee Act, which was enacted in 2005. Now it is known as Mahatma Gandhi National Rural Employment Guarantee Act, which provide 100 days assured employment to each and every rural household. So we can't say that right to work means Narega or Manrega. So this right to work and right to economic security, it means that there is unequal distribution of wealth among the Indians. So these rights are not available in our country, India. Right to life and liberty is restricted by a number of clauses like the security of the state and public order and morality. Yes, राइट टू लाइफ, जीवन का अधिकार, स्वतंत्रता का अधिकार, इनसे भी हमें लिया जा सकता है। देश की सुरक्षा के नाम पर ये सस्पेंड किए जा सकते हैं, या पब्लिक ऑर्डर जो कानून व्यवस्था को बनाए रखने के लिए हमसे इन्हें छीना जा सकता है या कुछ समय के लिए सस्पेंड किया जा सकता है। Similarly, there is provision of preventive detention and suspension of fundamental rights in the time of emergency. Yes, during the emergency time, mostly fundamental rights can be suspended by the parliament or by the president, because president is working on the advice of cabinet and cabinet is headed by the prime minister. Language and words of fundamental rights are so complicated that it makes a lawyer's paradise. It means that a common man can't understand the legal documents of fundamental rights. So it makes a lawyer's paradise. It means that a educated person, a legal person, a lawyer can understand the language and the words of fundamental rights. So these are the bases on which the critics are criticizing the fundamental rights which are given in the Indian Constitution. Thank you and have a nice day.